Mr. Jacob, I have a question for you. I believe during your deposition before this committee, you said something to the effect of you'd read every word written about the 12th Amendment, the Electoral Count Act, and historical practice. I know in response to the chairman's earlier question, you gave your bottom line conclusion, but can you tell us a little bit about the process that you and your colleagues went through of researching this issue and what conclusion you came to after your thorough research?
So, you, as a lawyer who's analyzing a constitutional provision, you start with the constitutional text, you go to structure, you go to history. So we started with the text. We did not think that the text was quite as unambiguous as Judge Luttig indicated. In part, we had a constitutional crisis in 1876 because in that year, multiple slates of electors were certified by multiple slates. And when it came time to count those votes, the antecedent question of which ones had to be answered. That required the appointment of an independent commission. That commission had to resolve that question, and the purpose of the Electoral Count Act of 1887 had been to resolve those latent ambiguities. Now, I'm in complete agreement with Judge Luttig. It is unambiguous that the vice president does not have the authority to reject electors. There is no suggestion of any kind that it does. There is no mention of rejecting or objecting to electors anywhere in the 12th Amendment. And so the notion that the vice president could do that certainly is not in the text. But the problem that we had and that John Eastman raised in our discussions was we had all seen that in Congress in 2000, in 2004, in 2016, there had been objections raised to various states. And those had even been debated in 2004. And so here you have an amendment that says nothing about objecting or rejecting, and yet we did have some recent practice of that happening within the terms of the Electoral Count Act. So we started with that text. And I recall in my discussion with the vice president, he said, I can't wait to go to heaven and meet the framers and tell them the work that you did in putting together our Constitution is a work of genius. Thank you. It was divinely inspired. There is one sentence that I would like to talk to you a little bit about. So then we went to structure. And again, the vice president's first instinct here is so decisive on this question. There's just no way that the framers of the Constitution, who divided power and authority, who separated it out, who had broken away from George III and declared him to be a tyrant, there was no way that they would have put in the hands of one person the authority to determine who was going to be president of the United States. And then we went to history. We examined every single electoral vote count that had happened in Congress since the beginning of the country. We examined the Electoral Count Act. We examined practice under the Electoral Count Act. And critically, no vice president in 230 years of history had ever claimed to have that kind of authority, hadn't claimed authority to reject electoral votes, had not claimed authority to return electoral votes back to the states. In the entire history of the United States, not once had a joint session ever returned electoral votes back to the states to be counted. And in the crisis of 1876, Justice Bradley of the United States Supreme Court, who supplied the decisive final vote on that commission, had specifically looked at that question and said, first, the vice president clearly doesn't have authority to decide anything, and by the way, also does not have authority to conduct an investigation by sending things back out for a public look at things. So the history was absolutely decisive, and again, part of my discussion with Mr. Eastman was, if you were right, don't you think Al Gore might have liked to have known in 2000 that he had authority to just declare himself president of the United States? Did you think that the Democrat lawyers just didn't think of this very obvious quirk that he could use to do that? And of course, he acknowledged Al Gore did not and should not have had that authority at that point in time. But so text, structure, history, I think what we had was some ambiguous text that common sense and structure would tell you the answer cannot possibly be that the vice president has that authority. As the committee already played the vice president's remarks, there is almost no idea more un-American than the notion that any one person would choose the American president. And then unbroken historical practice for 230 years that the vice president did not have such an authority.